12th of August. This is Newburgh Large City School District Policy Committee meeting. Present today, we have our President of Board, Ms. Juanta de Ed. We have Clerk of the Board, Matthew McCoy, Policy Member Ray Bergarelli, Policy Committee Member Ray Bergarelli, Ms. Onyx Peterson, Margot May, and Policy Member Philip Howard. If we can just go ahead and hand the meeting on over to Ms. Peterson to get the policies.
Okay, so 1.01 is policy number 0100. I just also want to state before we begin that many of these policy updates are required and recommended by NECSD, and some of the policy changes also have to do with changes in federal and state regulations and laws, and that is why we are here. We had a big update that was given to us by NECSD at the end of June that required us to look at some of our policies and update them over the summer. And that's usually not customary, but it happens. So the first policy is 0100. And this is just to comply with some federal guidelines when it comes to Title IX and discrimination. So on that policy, there are different things that reference website accessibility. There were some changes with making sure that websites are accessible to persons with disability, that we have accessibility tabs within our websites, and if they are not maintained, the district has to designate an individual to be able to take care of those problems. There also was some terminology changes with Title IX, and that we need to just come into compliance with federal law.
Anybody have any questions?
No, but I changed the title from Director of Technology to, Assistant Superintendent for Technology to Assistant Superintendent, Chief Information Officer, and Data Officer, because that's the correct title. Mm-hmm. That's the only thing I did.
John, Phil? So we're updating the policy. Were we in compliance, though, already, as far as, how we had the website structured and everything?
So in the policy, you will see there's certain dates that have been given to us to be provided. There's certain aspects and changes to the website that if you go on, you will see now, but there is a full format that the federal government is requiring that all websites have the ability to enlarge and to be able to be used with disability software. So they're giving us some time to put it in, but we need to have it compliant by those dates.
It's a date in 2027.
Yep. Thank you.
Okay. The next policy is our information and data privacy and breach notification. So this policy is also a revision on regulations and really it is making sure that we are following NIST, the NIST framework 2.0 for data security and privacy. This is a national cybersecurity framework that our state DPO has mandated that our school systems are also abiding by. It also puts some additional provisions around personally identifiable information. It also talks about what is personal, really clearly defining and expanding what personal identifiable information. And it also goes into, making sure that we understand that there's a parent bills of rights. When the district uses third-party contractors for software, what does that mean and what provisions we must follow? If there is a breach of personal identifiable information, what are the provisions that we must do in terms of notifying the parents, notifying the state regarding those things? So it's just an update of what our current policy is, but then also really going into greater detail about how we report incidents of ransomware attacks, cybersecurity, different things that would happen within the cybersecurity framework. And I think the state has started, New York State is one of the few states that does have a a data privacy and protection clause, and this is just further expansion to protect student information from vendors.
Your current policy has most of the information in it. The biggest change was this reporting of cybersecurity incidents, ransomware, and, payments that are made. That's relatively new, and that's now required. They put it in the regulation, I put it in the policy, because your policy has everything that is both in their policy and the regulation. So I saw no need to split it into two instead of having it all in one place.
Any questions? No? Thank you.
Okay, so I think this one, the notice of this was, I think Mr. DeRay had asked and proposed something with legal for this one?
Yes. And David looked at the policies, and Matthew, do you have those, or do you want me to give them out?
What's up on BoardDocs has been revised.
Okay. Yeah, but I have them printed out, too. Yeah, because if you want them, I do have them as well.
I don't think I have the first one. I know I have
little one?
23, that's 2325.
2340 is this one.
Okay.
Okay.
All right, and 2340, okay.
Still do you?
You
I gave them
2340?
to you, right?
Did you? Okay.
Anybody else? Okay.
We're going to have to backtrack a little because on these policies, we have to, the first policy is for the next board meeting. I'm proposing for policy 0100 for the website ability of first read and adopt. And for policy 8635 of first read and adopt at the next board meeting. This next one this is a proposal, I know you guys are discussing, and you guys will decide whether it has to be a first read or adopt.
Any questions?
I certainly don't have.
How does this, because it's listing certain places, and these are all public, as in, state institutions and things like that. But what about, conference rooms at a Dunkin' Donuts or the lobby of a hotel? Because I know that was an issue before that some people raised, but it's not really a public place because it's a private,
But
hotel,
it's still a
private
public
business.
place within the private business.
Okay.
There are places within the private business that are basically accessible to the public. And if they wanted to come. Oh, not zero. This is 2325.
Okay. Oh, we're on five.
Oh, I'm sorry. What's the other
I
one?
mean, I know there's sort of, they're sort of covering a lot of the same territory, sort of.
Right, well, 2340, I believe, is your current policy, and it basically deletes information about notice of meetings and use of remote locations.
Okay.
So it was really mostly deleting language and having a more comprehensive video conference of board meetings. And Mr. DeRay, did this come from you? Yes, okay, that's what I thought. I'm just confirming that.
Okay, so any question, no questions then?
Anybody have questions?
No, I'm good.
There's one thing. Oh, no, that's the other policy.
So point of order, we're on number 3, which is 2340. I need to know what the committee's direction is in terms of how is this going forward after the committee. Is it going to the board for first read, adoption, first read only? That's what I'm looking for.
I would say we're moving it on for first read, take a vote on that. How's everybody feel? First read, yeah. First read, yeah.
Thank you.
Receipts. So the next agenda item 1.04 is 2360.
That's where we're taking out the one sentence, is that minutes, the minutes one? But if we don't address that in the other two policies, why are we taking that out of the minutes policy? Mike?
Yeah, so yeah, I saw that too, and I was wondering, why wouldn't we
Just keep it.
note that someone is remote? Well, why wouldn't we note that in the minutes? Why would that be a
You're supposed
problem?
to. You're supposed to note it in the minutes.
So where did the
This
direction
is the
come to omit
reference
that?
under extraordinary circumstances.
Yeah, we don't need to reference that at all since you never adopted extraordinary circumstances. And frankly, most of the districts do not have it. And the ones that have it aren't doing it correctly anyway.
Okay, so it's just specifically for that type of instance, extraordinary circumstances. Okay.
It's a totally separate process of adopting it and having it and using it, and
Okay. Any questions?
they made it more difficult than they had to. The state, that is.
And that's also needs to be moved on for the next meeting, or?
What's the committee's direction? First read and adopt? What would the committee would like to do with that one?
I would think first read and adopt, right? Because it's pretty short and sweet. Yeah. And thumbs up.
So the next
1.05?
is 1.05, video conferencing. I think at one point in time, the policy committee did look at this policy, and I don't think it was moved forward for adoption, so this was the draft policy that was given.
I didn't know where it had come from.
Yeah. They had it a long time ago, and then it didn't move forward. They decided not to adopt it, so.
Any questions on this? No? Mr. Ray? No? This policy or the policy that we were speaking about before that, the,
2340?
is there anywhere that would be appropriate to get into the actual mechanics of, like, if you're in a conference room, is everyone supposed to be looking on the same laptop, they just bring their own device, it's whatever, is there any direction there should be, written in or anything like that, or it's just?
It's pretty prescriptive. I don't think it talks about, your personal computer and, nobody else looking in on it. It may be the only way that a member of the public who is there with you and you, as a board member, can be shown on a screen so that the public can observe. Because if the public can't see, hear, and observe, then you're not in attendance. And it does say that in here.
Okay.
And once you can't be seen and heard and observed, and the issue can't be fixed quickly, then basically you're no longer at the board meeting until such time as it is fixed. And because through video conferencing, you are considered to be part of the quorum, if that person makes the quorum and leaves, don't have a board meeting any longer.
But the people that would be coming to the remote location would have the expectation of being able to listen to what's going on at the meeting.
Yes.
So that's where I'm saying, like, the specifics of,
Well,
everybody's on their own phone, everyone, has to watch on the same laptop.
I would think it would be through the board member's computer where, they're listening, perhaps. And, because I don't see putting, or basically, I can tell you that when I listen to the board meetings, and I do on YouTube sometimes just to see what's going on, and someone else in the same house it's not necessarily totally perfectly synced.
Because in the instance that we've had previously where someone was in like the lobby of a hotel, a cafe or something like that, it's an environment where there's other people So, you know, you'd probably want to have earplugs in, but if somebody else wanted to observe the meeting, how
They would.
would there have to be a provision for them to be able to, you know, connect to their laptop or something? I don't know if I'm overthinking this, or,
It's connecting to the laptop or being able to see what's going on the laptop. It may, I don't think that there is an answer, a perfect answer to that. And even if you're in a hotel lobby, there are usually little nooks and crannies where you can have reasonable privacy.
yeah, this isn't the kind of thing I imagine is going to be happening.
Correct, not
But-
a lot, but it does happen occasionally.
Okay.
It actually happened in a school district when this was relatively new, and they had put, it was a hotel in Florida, the state of, and it just happened to be that a resident of that community was in Florida at the time and remembered and went to the hotel and called the school district to say, where do I go? You know, what do I do? And at that point, nobody had a room number or had a place, but that was very early on. That's why it's important that it say in the lobby or where to meet.
It does say if a public access and remote location is denied, material delay or interrupted, or video conference connection prevents the public from hearing, seeing, or identifying the participating board member, the board president may suspend the meeting. So
Or
if there's a problem.
suspend the meeting
Or,
But that's saying it is, the onus is on the board member to be able to provide. Okay, all right, very
It
good.
would only be suspended to give them the opportunity to reconnect. That's really,
Yeah.
it's not to suspend it for an hour.
All right. Were there anyone have questions? Yes, Mr. Howard.
So if a situation like that arises and the quorum is maintained, they can continue the meeting. But what about the people that are there that don't have access to the meeting? That's,
You mean people who are at the remote location? Well, if the person is no longer in attendance at the meeting because they cannot reconnect, they're not able to observe and see, they're gonna, it happens all the time. There are technical issues that occur all the time. You've had them.
so if that member does break the quorum, then the meeting is.
Then the meeting is, if that's the person who made the quorum and they cannot reconnect pretty quickly, then you no longer have a meeting.
Meeting's over, okay. Good to move this on for discussion and possible adoption?
Point of order, is it first read or is it first read and adoption? That's a big difference.
You're right.
Read.
Just first read, no adoption. Okay. That sounds good.
Substantially different.
Yeah, you're right. Well, we can always table.
okay, so the next 1.06 is the physical restraint policy. This is another update that was required through just policy, different aspects of the current policy, certain language, certain time terminology, just clarifying the timeout restraints for students with disability and making sure that it's tied to their behavioral intervention plan. It also just expands to the scope to students, to all students, not just students with disability. We had this policy and it was really focused on our exceptional learners. It also talked about adverse behavioral interventions, placed some parameters around timeout rooms, though we don't have many throughout the district. It also really put into concrete language parent notification and how that must be done. And then the data collection requirements that are required by the state when the use of a physical restraint is done within district.
You think we should add a sentence under aversive interventions that says the school district does not use aversive interventions?
I mean, I think it definitely is something that the,
Prohibited
it's
by law.
prohibited by law. So I mean, if we felt like that would strengthen your recommendation, I think, what section, what page is that on, Margot?
It's under
Ms. May?
prohibitions.
Oh, yeah, prohibitions. I just deleted it. I didn't, I mean,
Oh,
I,
it's still here. It's a definition of what they are.
Oh,
and
yeah.
what they're not. But, you know, I think it's very important to say that we don't use them. I mean, if they are prohibited, so.
yeah. So that's letter, I'm just trying to see what letter you're in.
Next to the last, it's B.
B?
B prohibitions, 1 aversive interventions. That's the policy. No, this is the regulation, sorry.
Okay, that's the
I'm
regulation.
confused, yes.
I'm like, that's not, I'm like, because I know I took it out, because I know it
Yes,
has
yeah,
to
I
come
saw
all the
that.
way out.
I saw that, but
In the regulation, you're
it's
recommending.
actually in the policy too, in the one that NISBA recommends. But my thought is, you always say that we do not have we do not conduct aversive interventions in this.
Let me just see what I put.
I think you just took it out.
I think I just took it out. I completely struck it from the
Yeah.
policy where I said that whole identification, but if you feel like it should be added back in and just say that we
Well,
don't
no,
use,
the only thing I would say is that we don't use aversive interventions.
okay. Do you think that that's something that should just be added to the top? Because it talks about for the purposes of the policy,
Staff training, you see.
as required by state
That would
regular
be in
district will utilize proactive evidence, research
Yeah,
through.
this is really just updating your current policy and reg. Because the state regulations changed after you changed your policy to make it consistent, but then it had another set of changes.
Do you feel that in the second paragraph, if you're asking us to put the adversive behavior, that we do not, do you think that that would be something that should be included in the second paragraph of the policy? Like at the top and not, because I've completely struck in
I
it from,
took it, I don't want it in the title.
yes, so I changed the title to timeout and physical
Right,
restraints
right.
all students.
That's what we all have.
Okay, so then, do you want, I know you made the statement about the aversive,
Yeah, well, it's only in your regulation, actually. You took out the definitions, so. It's in here. Now, you know what? Don't worry about it.
okay.
But if you're not gonna have it in the
I
the policy, why do we need it in the regulation?
All right, so then I didn't strike it from the regulation.
Right, that's the whole thing. But it says, it's just under prohibitions, so you can't, they're illegal. If you hadn't been doing it prior to 2019, you can't use it now, so.
Right, and I think the reason why I kept it in the regulation is
Just
for,
because of the prohibition.
because of the
Okay.
prohibition, but then also to define what the behavior is, so if people are doing it, I'm telling you not to do that.
Okay.
So that's why I kept
Okay,
it in the
that's okay,
regulation?
That's okay.
Okay. All right, so that is, I don't know if there's any questions about the use of the timeout.
Mr. Howard? No? Mr. Ray?
It's all very technical, and it's really you have to make sure that the people who are most likely to have to use this are well-trained and every year.
Yes.
Because if they're not trained, I think your liability will be huge.
Okay, we good to move this to the meeting for, this is not a new, this is just a,
First,
It's a substantial amendment.
it's a substantial amendment to 43.
okay.
It is a substantial amendment based on the changes with state regulations.
So would you recommend just first read, or? Okay.
Okay, and then the next one is 5460, which is child abuse and maltreatment, just a reporting. This has to do with mandated reporting. There was changes on the state side regarding who should be named as mandated reporters within our policy, as well as the right to privacy of staff. So the state has changed the regulations. You must report who is reporting, and people have to be made aware of that. There's also information about just making sure the public number is stated, and that we maintain an ongoing training program, which is a part of our full annual training. We do an update every year as a part of our opening trainings, and then the toll-free number.
For the next policy meeting, I'm going to take a look at the policy rather than the regulation and update that as well.
Questions?
Ran out of time.
Okay. I was like, I know I gave the policy, but I know.
Good to move it to meeting for read and adoption?
What's
Point
your
of order, these are regulations.
Oh, we don't do that, all right.
They go to the board for notification, but the board does not have to approve the regulation.
Okay.
But when I revise the policy, it will.
Okay, 5700 is corporal punishment, and I think Mrs. May recommended that this go to policy?
Yes, I did. Yeah. Corporal punishment is prohibited in New York State. They changed the regulation having to do with corporal punishment. In the past, you were able to use it if somebody was going to hurt themselves or others, or there was the possibility of damage to property, but that was taken out because it's not considered severe enough to enable the use of any kind of physical interaction. And what's different is also that you have to report all incidents of corporal punishment to the state, whether they're substantiated or not substantiated. And the other interesting thing is that it's now classified as a child abuse in educational setting, so you have to investigate it as child abuse in an educational setting. That's the biggest part.
Questions? Mr. Ray?
I'm still on paragraph 2.
Okay.
It says,
Sorry, paragraph 2, the use of corporal punishment as a means of discipline or punishment is prohibited by the district. I believe there should be a period there. That's the end of the sentence. But then it goes on to say, except when a student is under arrest by law enforcement and handcuffs are necessary for the safety of the students and others. And we put two absolutes in there. They absolutely have to be arrested and they absolutely have to be handcuffed. However, if something's going on, a law enforcement officer can restrain somebody without them being under arrest, and it doesn't have to be with handcuffs. So I think it should be more broad.
I don't think that the regulation is more broad, though. I mean,
Well, forget about law enforcement. If you have medical professionals coming in, there are instances which you will have to restrain a child.
absolutely, that's what physical
But this is-
restraint is.
Specific to district personnel.
Well, district personnel and agents, including an SRO, for example.
So if a law enforcement officer is restraining a student, just restraining them, maybe just holding them against the wall and saying, stop fighting.
Well, and that's, physical restraint when you have to stop the child from hurting themselves or others.
Right.
But the outside, if it's not the SRO, it's not your agent, it's the police. But,
So this policy is just for district employees. So when we bring law enforcement,
it's district
it's different.
employees, officials, and agents.
right. So it's a difference. So if a law enforcement agent comes in and help, that's different. This is just pertaining to district employees.
But an SRO is a law
Again, but
enforcement
it
agent,
says
sorry.
the law enforcement officer must have performed an arrest, and that's,
Why don't we do an arrest and/or too?
So SROs fall under a different category of employment, so I think that that's why they put them, because they're technically seen as district employees. We don't have SROs.
No, they're your agent. They're
They're
not your employee.
they're our agent. So it kind of falls under a different category. Yes, of the district. But I think what your question is that if I am a building principal and I call a
police,
police in and they restrain a student and they handcuff a student,
but they haven't arrested him.
they haven't arrested them, they're restraining them.
But they're not an agent.
They're not our agent of the district. They're a separate body. Yes, but they're not an agent of the district. They're separate and apart, and it's a police matter at that point, if we call them in to do that. You're checking something else?
I'm checking the regent's role.
We currently use Orange County Sheriff, right, as our SROs?
They're a contractor, so they're an agent.
Yes.
Has this been bounced with them too? Because if we're going to restrict personnel,
This is a change to the regulation, so they will be notified once it goes through about what that means, because they're acting as our agent, and it's a part of our contract with them. But it is classified as child abuse in an educational setting, which means when these things happen, we have to fill out a form, it's reportable to the state. There's a separate form and investigation that has to go along with that.
Let me read what's in the Regents rule. It says, for purposes of this subdivision, agent shall include but not be limited to school resource officers, except when a student is under arrest and handcuffs are necessary for the safety of the student and others. I'm just telling you, so, yeah. You're right. Well, no. You know, you made me question myself, and that's fine. Just, I can't tell you that I always agree with the language that's used.
can we dig deeper into that thing? Because sometimes you have to restrain someone with cuffs until medical
That's true.
personnel
Yes.
arrive.
Yes.
It doesn't mean the person's under arrest at
arrest,
all, you
right.
know? So that's, I just want to make sure we're not handcuffing, you know, people from being able to deal with someone in the safest manner possible, least amount of force
I think the police are going to do what they need to do.
The police, when they come in, is one
Yes,
thing,
and
but
that's
if
what
we're
this
going to
is,
have
yes.
an SRO and said, oh, well, but you can't do this, but I've got 2 kids, and these kids are 6 foot tall and whatever, but they're having, you know, whatever issues going on. It's,
Well, that's when you can use physical restraint so that the child doesn't hurt themselves or others. And then you just have to report it as an incident of physical restraint and, you know, go through all of the other rigmarole.
yeah, and like I said, I'm just thinking of the other side of, we have a contract with Orange County Sheriffs, and what will their reaction being if we're changing some of this verbiage? And they go, well, how are we supposed to be expected to do our job in a reasonable manner where we have to restrain someone?
So the question the board is asking is physical restraint versus corporal punishment. What are the differences of that?
Based on what we're reading, it's corporal punishment until the arrest, but there may never be an arrest.
But it may never be an arrest. Might be a situation where an ambulance has to come and remove.
But there are instances and times where the district can use physical restraint, and there are trainings that our monitors and our resource officers receive yearly and quarterly around physical restraint that does not equate to corporal punishment. So a part of that requirement is the handle with care training, are those type, how we restrain, face up versus face down, those different things. But if it flips in the course of the incident, it then can be corporal punishment, and it is child abuse in an educational setting, and there has to be an investigation and filing with the state. So I think that we probably need to clarify both definitions.
Why don't we bring it back to the next meeting? How's that?
Yeah, thank you. I think that's appropriate. We dig a little deeper, making sure that we're not, messing this up. Agreed? All right. Thank you.
Okay, so then the next one is 9520.6, which is, oh, did I do child abuse in the educational setting? Oh, I'm sorry. I forgot about child abuse in the educational setting, 9620, my apologies.
I looked to see whether or not we had a policy, and we don't have a policy on child abuse in an educational setting, which is a required policy, an important policy, part of which is because board members as well as employees are mandated reporters.
Mandated or required?
Required, same thing. Required, mandated, same thing to me.
Well, is there 2 levels of training, though?
They're different, it's different training, yes. And you should have that training as part of your training. it's not as important for a domestic setting because you're less likely to have the interaction that's going to result in a call to CPS, although there might be. But, you know, this is different. This is in the educational setting where something is done that could cause harm or severe physical harm. And there's a very, very prescriptive procedure for investigating and quickly by the building principal and reporting to the superintendent, and the superintendent notifying law enforcement if necessary. And if it's determined that it's not child abuse in an educational setting, you still have to complete the forms and maintain them, but you don't have to send them to the state education department. But this is a policy you must have.
And this is pretty much in line with what our neighboring districts have and everything.
Yes. This is basically the NISBA policy.
Any questions? Yes, Mr.
I have a
Dre.
question,
Yes.
because I'm trying to understand something on page 3, which is somewhat, it's contrary to the actual law. It says, in any case where the employee against whom the allocation is being made is the superintendent,
Yes.
the report of such allegations will be made to any board member
That's what it says.
who must promptly notify the entirety of the board. But the law says in any case where the employee against whom the allegation is made is the superintendent or the administrator, the report of such allegations shall be made to another administrator designated by the school. I mean, we're suggesting that on an allegation, just an allegation, and not even an executive session, the entire board is notified of an allegation.
So you wanted to say the deputy superintendent?
I like it, any case where the employer is made against the superintendent or whatever, the report of such allegations shall be made to another administrator or put that,
Okay.
made to the deputy superintendent. And the deputy superintendent, I suspect at that point, would contact counsel and proceed accordingly before, we're just at an allegation phase,
I understand.
you know.
Duly noted.
Was there anything else on that one?
Yes. The last page, I think it's the last page. Second to last mentions, the superintendent will be responsible for establishing and implementing an ongoing basis training program. I think that should just be tightened up a bit, that, you know, for new board members, it's within 30 days. For existing board members, it'll be by October 31st, or something should follow this, that it's just not a dangling, oh, we're going to train you. We need the training.
I think that there's two different things within this policy that I think that I need to clarify. So there's training for, the superintendent is usually responsible for the staff, which is the staff would be responsible for training, establishing a program for mandated reporting, which we already have. We've always do it. It's a part of our annual training. Every staff member is expected. There also was a change to mandated reporter training, which the district did implement this year, and people had to retrain because the state changed the regulation around what was required for this. So when it comes to,
This is 23B though, right?
Yes, but there's required training for employees for both domestic
says
settings
and educational, so it's a part of the both. The state changed the requirements, so this year, both of those trainings have to occur, and we do that at the beginning of the year through our GCN program. And then we do also organize training for school bus drivers as well. That's a part of their beginning of the year training. And Trish started doing that about 2 years ago, the transportation department. But I think that this training that is being spoken about in this policy has to do with staff. It's not board. So I don't know if that's needs to be delineated differently within the policy. And I think the other portion of it that you were talking about, because this is the first time I'm also seeing this. I think that we need to kind of iron out with the allegation. I'm trying to find that place that you were reading, Mr. DeRay, before. Because if there is an active child, we are mandated reporters, so if it's against the superintendent or if it's against a high-level administrator, as employees, we are required to call and then notify our principal or meeting, but we're mandated reporters.
That's domestic setting. If it's an educational setting, there's a different set of procedures.
Okay.
It's generally the building principal who is the first contact to undertake an investigation. And then the building principal reports to the superintendent.
Okay. Yes, because, yes.
And then the superintendent would contact law enforcement in an appropriate case, and so it's not the same thing.
Understood. I'm going back to, just became a school board member. I'm not from the educational community. And by this, I'm a required reporter. How would I know that without any sort of training?
Well, that would be in the school governance training that every new school board member has to take,
Okay.
or should be taking. I mean, they really are required to take it, but not everybody seems to finish it.
Everybody here has finished it.
Yeah.
And everybody's certified.
That's wonderful, I'm glad. But I think that there should be an annual refresher, even like the GCN training. And if you want to have a time frame during which, that
I'm
can.
sure there's some sort of module available on
That's
the
the
internet that
GCN, yes,
you
there
sign in, it knows you were there, and you're all set.
I would have to research if the GCN has the general child abuse, and then we can make that available. Is that what they asked?
GCN should have child abuse in an educational setting as one of their modules. If they don't, it's not, then your staff are not getting it.
No, GCN has that, but I think the other side of it, but I'll double check that.
Right, because they're both different kinds of child abuse. And we're supposed to be protecting students.
So we should bring this back for another meeting or first read with the changes that we've talked about today?
I'll just tweak those few things and send it back.
Okay, so move it on for first read then?
First read only?
First read only, right? And 1.10 last.
So 9520.06. The rights of employees to express breast milk in the workplace. So this was a law that was just changed recently within the last, about the right to have areas and times for the expression of breast milk. So this is Department of Health, Department of Labor kind of policy that we need to add for our employees.
Okay, any questions? No? No?
And there are a lot of standards and provisions that you must follow,
Yes.
and notification requirements, just to let you know. Not in my time.
Have something?
Yes, and then just the other thing, I think Matthew just let me know that NISBA did finally get back to us on some of our requests for our review. So I think our next, yes, so they finally provided us the 5,000s at the beginning of July. So we have that now to kind of try to move forward with the 5,000 policy review.
With that last one, we're good to move it on to next meeting for read and adoption? Yes. That's it?
Mr. Bergerelli, can I summarize?
Yes, please.
Okay. Non-discrimination and equal opportunity policy, that's the first read and adoption. 8635, information data privacy, first read and adoption. The next policy, notice of meeting, that's a first reading only. 2340, minutes, first read and adopt. 2325, the new policy on video conferencing, just a first read. 4321.12, physical restraint, first read only. Child abuse mandated reporting, regulation only, so that's just gonna go to the board as an FYI. 5700 corporal punishment, it's gonna go back to the board's policy committee, the next policy committee meeting. 9620 child abuse in an educational setting, first read only. 9520.6 rights of employees to express best milk, first read and adoption.
Sounds good. Anybody have any? No? No? Motion to adjourn? Second?
All in favor, say aye.
Aye. Thank you very much, everyone.
So Margot, there was the other.